220-9788, 220-WSTU. Again, that's 772-220-9788 or 220-WSTU. It's the number in the studio. If you write the number down, keep it close. You can use it for our show, but all kinds of other shows here on WSTU that allow call-ins and are there to help you as well. WSTU provides a lot of community service programming, and a lot of their shows are based on things that people need and can utilize. So we're here to do that for you as it relates to condos and HOAs. My name is Mark Breckbill. I'm a local CPA and a community association manager, and have been dealing with condos and HOAs from a professional standpoint for about 25 years or so. And but my co-host and person that almost everybody calls for, although I did get a call last week on an accounting question, but for the one in a year. But the person that everybody calls for is our attorney and the person that's been doing this for a lifetime, Peter Mullengarden. Good morning, Peter.
Good morning, Mark. How are you?
Good. And Peter's been in this business now for, I guess, a long time, right? I mean, I always make numbers up, but it's been at least 35 years.
35 years.
Yeah, 35 years. So that's a long time to be doing it.
Yes,
And finally, and you were also now they've got designation for attorneys that are have a specialty in condos and HOAs, right? You've got that.
A certified specialist in plan development and condominium law. Ta-da.
See, you're certified. I'm certifiable. This works out good. I think this is a good team.
Works out very well. There you go. How about that?
Yeah. But for our listeners out there that are maybe new to the program or just kind of a little bit of the ground rules, there really are none. We're here to help you. We do give you a couple caveats. We can't give you a hard and fast legal answer because we don't have your documents. So we're going to give you the best answer we can. We kind of kiddingly call it a radio answer, but it's the best you can do when you don't have all of the information that you need. But so we'll give you an answer based on your interpretation of your documents, standard practice, law, cases, and other things that may have a bearing on your particular situation. But know that if you need a hard and fast answer, or you're a board and you're looking for, maybe facing some sort of legal challenge, you should get with Peter or with your own attorney and sit down, let him have access to the documents and get there and give you an answer that will help you come up with a good solution to your problem. The other thing is that we typically will, because we don't have documents and we're talking on a broad scale, we typically talk a little bit broader than the question, so that if there's somebody out there that doesn't maybe have the exact same problem, but very, very close, we can hit it and they don't have to worry about trying to call in, because some people are shy about calling and they don't like to. Along those lines, there's no reason to be afraid. Mike is not very, he's a nice guy sometimes, but you just got to give him your name. You don't even have to give him your name. You can give him anybody's name, and he will he'll take the question and get it on the air for us. And we don't need your association. Just the name and the problem, and we'll try to answer that for you. So if and so those are the only ground rules. Otherwise, it's pretty straightforward. And we're, like I said, we're here to try to help you out. So let's see. We've got a caller, Connie. Good morning.
Good morning.
Yeah, I actually think I was going to get to a question you brought up previously, but anyway, go ahead. Give us.
I had called a couple of weeks ago.
Yeah.
About the minutes of a meeting, which I took
Mm-hmm.
and transcribed, and they were turned down because the president wants to make a change, and the change is on one of the motions that was taken a roll call vote on, and it passed, and now he wants me to eliminate them, and I refuse to. So what request do I have?
Eliminate the
certainly,
whole issue.
Yeah, one of the motions that was voted on and passed.
Yeah, he indicated that they were kidding.
I'm sorry.
I'm confused.
Didn't you tell us, Connie, a couple weeks ago that he basically said that that it wasn't serious? They were just kidding.
It was a joke.
Yeah,
but
that's what
yes,
he said.
exactly. But there was a roll call vote, and it did pass.
Was it an issue?
I'm
sorry, Connie. Was it an issue that was on the agenda, or was it just something that just kind of like came out of left field?
Well, actually, if we want to make a motion or something to discuss at the following meeting, we have to submit it to him, and he decides whether we can bring that up or not. If he doesn't like what we want to talk about, he doesn't, we can't bring it up. Okay? But
okay. Well, look,
so
I mean,
this was
something
that...
All right, as an overall comment, okay, I'm just gleaning from what you're saying here, and it sounds like the president is sort of, running this almost unilaterally.
Well, he's also the president of the POA. He's the president of our section, and he's the CAM in the office. So he's got it like all tied up.
Yeah, and he's paid by the association as the CAM.
Yes, very nicely, I would add, like New York salary.
Well, okay. Going back, I guess just going back to the minutes. We'll just start with that.
Okay.
This was a board meeting, correct? I mean, so
yes.
I'm assuming this was a board meeting. Okay. So these are minutes of a board meeting, and the board decides, quite frankly, once the draft minutes are dispersed, or at the next meeting when the minutes are approved, and then board members can then make motions to change the minutes, correct the minutes. That is not a president unilateral decision. Okay, these are board meeting minutes of the board. Okay,
right.
And now he could, or any director, at that meeting when the minutes are going to be approved, can say, no, I want, let's change this, let's change that. I make a motion that this is not correct, or whatever. Okay, and the board votes. Okay, and every director has one vote, just like every other, vote. The president or the vice president or whoever doesn't control the proceedings in the sense of, unilaterally making decisions. They just run the meeting, the president typically, but he doesn't, he or she doesn't control that kind of issue. So,
I don't want to interrupt you, but at every meeting, they dispense with the reading of the minutes. They vote not to read the minutes. So.
Well, that happens frequently. Well, that does happen.
Oh, it happens all the time. Every month. I have never.
Well, that's fairly common though. But not to interrupt you. I guess we'll interrupt each other. It is fairly typical to take a motion to dispense the reading and deem them approved as written. Okay, that's not wrong necessarily. Okay,
but is that proper? I've been on the board I've been here for 5 years, and the minutes have never been read. And since I'm on the board, I request to have the minutes read for those who weren't there at the last meeting, and they're just not read. They just,
No, there's no requirement that they be read. Okay, but then again, this is up to the entire.
Is there a requirement that everybody else or anybody who wants to see the minutes can see them?
Oh, definitely. Oh, yeah. The minutes are part of the official records and are available for inspection by any owner, director on down. But as far as the actual approval of them, it is relatively common. Some associations, they read the minutes and then approve them. Others, they have a vote to waive the reading and deem them approved as written, because generally the minutes are dispersed to the directors, prior to the meeting, so they've already read them, before the meeting starts. So to be more efficient, rather than going through the thing of reading them. Now, other communities, they read them. Again, there's no right or wrong there. As long as the minutes are accurate and they're available for review, and they've been approved, that's fine.
These minutes.
But you can make your. But when that. I'm sorry. Go ahead.
Because they want me to eliminate certain parts of the minutes.
Well, no. I mean, that's a decision to be done at the board meeting. Okay, you basically draft the minutes as you deem best, right? Being your role as secretary, I'm assuming, but
it's not even my role. There was nobody there, so I just took it.
That's fine. You did it fine. So you took the minutes, okay? So basically, you draft the minutes, you submit them to the other board members, and then at the next meeting, they'll come up for approval. There's no obligation on you to change them. You just did them as you deem best. If they want to change them, they would do that literally at that meeting. People would make a motion.
So,
I'm gonna.
All right. At this point, he wants me to change the minutes before they're dispersed to the other board members. He wants to eliminate that. He said it was a joke. There is no joke when you have a roll call vote, and it's 10 people.
Doesn't sound like a joke to me.
Yeah.
No, it doesn't. And a couple of weeks later, it was just a joke. Well, hello, the vice president was the one that brought it up. She made the motion. It was carried. It was a roll call vote.
If he wants to make that motion at the meeting to eliminate it, then that's the time to do it.
Okay.
I know, but I would just, if I was you, I would say no. I'm not doing that. It's in the minutes. That's what I heard. We had a vote. End of story. What's he going to do to you? Beat you up or something? I mean, no.
No. I'm not going to do it. Absolutely, I'm not going to do it.
And I wouldn't do it either.
Yeah. Well, I believe it's against not only me, it's against the law. Oh, it must be.
Yeah. Well, there is no strict statute on that. This is more like a Robert's Rules of Order kind of thing, and whatever. But basically, the minutes are to reflect the business of the meeting. In other words, who was there.
Reflect the minutes of the meeting.
Fine, and that's what you would say. And again, if he wants to change it, the proper way to do that, the proper forum, it would be at the board meeting, where you would, when the minutes come up for approval, rather than, waiving the reading, read them, and then someone can make a motion. Hey, no, I want this changed, I want that changed, and the board votes on the minutes.
And Connie, if
I'd like to live in yours.
Well, Connie, if you here's what I understand, because I remember a couple weeks ago we were talking about this and how difficult this is, and it is very difficult. But I think in this situation, you kind of got to use the rules of the Robert's rules for you, or the the standard practice. So if it sounds like this individual will then will submit the minutes without that motion in it. That's a possibility.
Right.
You want,
but I'm not going to change them.
Right.
That's up to him.
So, but you'll have an opportunity to emphasize or point out the issue if you want to. And that is, let's say they dispense with reading the minutes. Okay. That takes a motion and a second. As soon as the second's made, you can ask for discussion. And at discussion, then you can bring up that motion. And you can discuss that motion, which will become part of those minutes, and they have to allow for discussion. So once the second is made, before they vote, you step in and say, I want discussion on this issue, and you can then discuss why the minutes are right or wrong, and if you want to emphasize that point, you can. So if there's something in those minutes that you want to make a point about, even if it's to say, I want to verify that this is correct. Here's what happened, and whatever, so that you can. So you've got that opportunity, even though like Peter said, most of the associations, most of the organizations I'm involved with, we dispense reading the minutes because the board's had a copy of them. They've read them. They've had a chance to look at them ahead of time. And, most guys.
That's all true.
Yeah.
That's all true.
So, but there is always, there is this possibility of being able to make your point because they do have to approve them. And that requires a motion and a second. And when that second's made, there's an opportunity for discussion. So okay. I would look at it that, and depending upon what he does and what happens, you have the opportunity to either add that or clarify it at the time, is what I would do.
Okay, we'll give it a shot.
Yeah, and one of the things that I wanted to, while you're on the line, Connie, this was a question I was going to bring up this morning, Peter, because we didn't get to it last week because we had a call, but that, what are the restrictions? I don't remember now, the restrictions on an association hiring a board member as their property manager and paying them for that. Are there what are the restrictions on that? What are the opportunities there? What are the requirements for disclosures of salary and that kind of thing? What's the rules? So
that's a risky thing to do. I mean, gotta be careful you're not paying a board member. Okay, to be acting as a board. Obviously,
he's also the CAM.
Obviously, that's an interested transaction. Obviously, he could not, vote on that as an interested director.
On what?
It would be subject
on his salary or contract or anything else. He's not allowed to vote.
Right, anything else.
Yeah, he can't vote on
that roll call vote.
Yeah, it would have to be approved by 2/3 of the uninterested directors. The owners could literally cancel that kind of contract if they wanted to, because that's an interested transaction. So I tell my associations to to shy away from that.
The treasurer is also paid, and he's also on the board. So they've got the market on.
The treasurer is paid. Now you can't be paid as a treasurer unless did the owners approve that your documents provide that you can be paid.
I'm only here 5 years. I have no idea what they did. They've been doing this for years. You can tell by the financial reports, how much they make. Each of them. They're both board members. One is the treasurer. One is the president. And the president manages the office, and the treasurer is the treasurer in the office.
Again, these are unpaid positions, and I don't know. This association, you guys could be
board members, but they are paid. They're paid nice salaries for running the office. I would like to get an outside contractor.
You guys may be crossing the line, quite frankly.
I know we're crossing the line.
Yeah. Not supposed to be paying these guys, so.
Yeah.
I'll just leave it at that.
No, as office manager in CAM.
Yeah, you can't. The board members are not supposed to be paid. You can't.
They're not paid. Well, being board members.
Yeah, they are in a roundabout way.
Sounds like they may be, though.
Yeah, that's really. I think the state would have a problem with something like that.
Yeah, I do too.
Now, the president might be able to get away with it because he's got a CAM license, but I don't think the treasurer will, because the treasurer's operating.
He has a CAM license also.
Well, I still.
Yeah, but he's not acting as a manager, though.
Yeah.
Well, this guy works 3 hours, 3 days a week, and I'm telling you, a New York salary.
Well.
Anyway.
Yeah. That's interesting. I wasn't, I like Peter, I tell my clients to shy away from that kind of thing. That there's only bad things that can happen, not only to your association, but to those individuals. Both that president and that treasurer are going to be open for all kinds of, I guarantee you that somewhere down the road, those individuals will be looking at fraud charges, whether that's true or not. Because it probably won't be. But when you put yourself in the position that you have that much control between two people, the internal control system is now broken down, so none of your audit work could be any good. because you have no internal control because you got two people that
I
are.
don't believe we've had an audit
Well,
in years.
and
We get an audit, but it's only the information that's given to the accountant. So, you know, he does the audit, but it's only the information that's given him. I was like making out your income tax. You give the information, and whatever information you give, that's how your taxes.
well,
you know,
auditors
on time.
have additional responsibilities. You know, and again, especially if it's an audit, not a review, not a compilation.
Right.
But if you're having an audit, auditors are required in an audit situation to obtain third-party information. We can't just rely on the information that management gives us. We have to look at invoices, or we have to look at contracts, you know, and bills. We have to look at that. We can't just do what they call analytical review. We can't just look at the numbers and say, okay, they look reasonable. We have a responsibility. We have to look at bank statements. We have to look at, you know, we don't necessarily have to confirm cash, but many of us do. You have to, you know, there's certain things that we're required to do to verify those numbers. But my experience has been in the situations now, you know, I've only got 25 years in this thing, but my experience has been that when a situation like this occurs, that usually it ends in disaster. And not because anything was actually done. Sometimes, and in most cases, the president was actually trying to do good. But when you set yourself up that you're the master and you're making all the decisions and nobody can say what to do and nobody's looking over your shoulder, you make a mistake. And when you make a mistake, that's not going to be viewed by the rest of the people as a mistake. It's going to be viewed as an intentional fraud. And that's
Right.
what happens. And these people end up, it's a disaster. They end up having to move. They end up facing charges. And I've seen that happen over the years. And nobody should ask to be in that position. Nobody should be put in that position. I really strongly believe that, because it's just not good for, you know, it's not good for anybody. This, you know, it's just ultimately is going to lead to bad things. But anyway.
So you do audits.
Yes.
You do audits.
Right.
What I would call a disclaimer, the last sentence is based on the information given. To me, that says that audit is based on the information that was given, not on all the information that I have. I mean, to me, that's a disclaimer. That's
well,
like
the audit report is a standard report, and there's no based on the information given. There's language.
Well, that's the last sentence on that.
There's language in the audit report that indicates that management's responsible for the financial statements and is responsible for the numbers. That it's management's
Right.
responsibility to have a system of internal control
The
and do all
correct
those
numbers,
things.
yes,
Right.
and a system that's correct. Right.
Now, there is a disclaimer. There is a disclaimer in most audit opinions in condos and to some degree in HOAs that has to do with the reserves and whether they're adequate. And that is a disclaimer that's put in that says that we're not engineers, basically, and so therefore
Right.
we can't give an opinion, and that it's based on the information that's been provided.
That's given. Okay.
Right, but that is a disclaimer, but just on the reserve amounts as to whether or not they're adequate, not relative to relative to the audit as a whole.
The actual audit of the.
Yeah.
I mean, you give me a fistful of information.
Well,
You always do.
I'm glad we could help. So, but and you know, if you know this president well enough, or the treasurer, you know, as not even as a board member, but as a friend, you ought to discuss it with them and tell them, look, you know, you've heard of situations. This ends in disaster, and you know, it truly is no good deed goes unpunished, and they truly believe they're doing the right thing, and I think they are trying to, but you know, they think they're saving money, they think they're doing a lot of things, but in the long run, you know, it won't be pleasant. You know, that's the problem.
Well, they think they're saving money, and maybe they are, but if they're doing it in an illegal fashion, that's not helping anybody.
Well, or even if they're just setting themselves up for question that down the road, you know, they could get, I mean, when somebody, it's unfortunate, but when somebody accuses somebody of something, it's almost the same as if they did it. And by then, when this is your home, you have no choice but to leave. You know, I mean, you got all your neighbors that think you're a crook. You know, I mean, it's horrible. It's just a horrible situation. That's why in a corporate environment, different story. There's some of those kind of things, you at least don't have to live with these people. But,
Right.
so anyway, I just would caution. I hate it when I hear these kind of things because
I mean, the Condominium Act currently provides that a condominium association cannot contract with a service provider in which a director has a financial interest.
right,
So, is the manager a service provider? I mean, they don't define service provider, but
right,
I mean, you really got to shy away from this. It just creates a lot of potential problems. At a minimum, it has to be disclosed, and they can't vote on it.
yeah,
Okay, but it might not even. I mean, if they're considered service providers, it's not even permitted.
Right.
So
yeah,
I don't really think they understand. I mean, when I went for the first seminar on 718, I read that thing frontwards and backwards and sideways, and I found a lot of discrepancies, and I brought them up occasionally. And well, that's not what we do here. Well, that's what 718 says. Well, no, we do what we, how our blue book is. Yeah, but you wrote your blue book, and you didn't, you're not following 718. So I'm always hitting my head against a brick wall. And I'm a snowbird. So the couple of, 4 or 5 months that I'm here, I try to kind of like do the right thing and steer things in the right direction. But it's always, they have the final say. If that's what he's got in his head, that's what they do.
yeah.
And he's got a board. I mean, it's a 15-member board, which is ridiculous.
Unmanageable. Yeah, that's unmanageable.
Unmanageable. And they've been on the board for 10, I don't know how many years. We only go back 7 years. They don't have anything longer than that. And some of them have been on for 10 plus.
Wow.
And they just vote however he says. And, it just seems odd that the office door is closed and there are half a dozen of them in there and they're just discussing things. And they come out, they have this board meeting and they vote unanimously.
Yeah.
I mean, we don't even have a foothold. So there's like 11 of them that will always vote the same, and the rest of us are like floundering.
Wow. Yeah.
So,
I'm.
you know what? You've been very interesting to talk to.
Yeah.
I'm sure I'll be calling back.
All right. Well, we appreciate it. And feel free to call.
Okay. Thank you so much.
Thanks, Connie. Thank you.
Bye-bye.
Bye. Yeah, it's always tough in those situations, and I once, Peter, a number of years back, I was in a situation where I was the head of the compensation committee for my church, and I was the head of it, and they asked me to chair the committee, and then after I agreed to do that, I found out that nobody would be on the committee, that I was going to be the sole person. But it was interesting because in that day, you had two groups of people. One that basically thought that the pastor could do no wrong, that he was close to God, and then the other one that the pastor could do no right because he wasn't God. So it was an interesting situation because, and this is what happens in some of these associations, is you've got a group of people that really believe they're doing the right thing, and they're adamant about it, and then you've got a group of people that, want to see the organization run a certain way, so that things are, protected. And there's just, and it's hard because you've got people on both sides, and it's hard to get people to come around to see how dangerous some of those positions are. And, but anyway, it's, but this is one of the things I wanted to ask you about today. And then the other thing regarding minutes, because this subject came up a couple weeks ago, and then it was in the paper. We have somebody from one of those firms that answers questions in the paper periodically about condos and HOAs. And the question came up in the paper was whether or not the person that was say they were talking about minutes, and they indicated that the minutes would just reflect that that there was a motion, a second, and a vote, and the vote was 3-2 or whatever. All right, and the question that was raised was, do the minutes have to reflect each director and how they voted? In other words, do they have to reflect a roll
The
call
answer is
vote?
yes.
Yeah, that's what they said. That it was yes, and I didn't realize that you had to put each one. I thought you only had to recognize, like, if it was unanimous, or let's say there was a dissent, that you would recognize the dissent. But I guess you have to recognize all of
Now, you
them.
have to indicate how every director votes, yes, no, or whether they abstained.
Okay.
Okay. Now, obviously, if it's unanimous, I guess we can figure it out. I
Right.
mean, if
That's what I was getting at.
because if the minutes said who was there, either in person or on the phone or something, and it passed unanimously, well, I guess everyone voted yes. So we could, but
Right.
you can't just say motion passed 4-1 or 3-2
Right.
or whatever.
Okay.
You have to say Joe voted yes, Betty voted yes, Susan voted no, and Bill voted whatever. I'm just using make-up names here, but so yeah, it's yes, no, or abstention for every director for every vote that's taken.
Okay. So, but you could, if, like I say, if it's unanimous, or if for example you had a abstention or a no, you could indicate who voted no.
Well, I guess if you said everyone voted yes except Joe voted no.
Right.
It
was 4-1.
As long as you can figure out from the minutes what every
yeah.
director's vote was, then that's okay.
Yeah, that's what I was getting at. I mean, I understood you got to record a vote, but and I know it's important to have, it was important to have those, especially the no votes, because a lot of times they determine what kind of rights that person has down the road. Especially maybe not so much on the board, but it can, if you were a dissenting vote on some action that turns out to be, to be wrong, then it may relieve you of some liability as a board member.
No, it's really important, because the board. I mean, I say this all the time when I do classes and lectures and board certification courses and whatever. That if the board does something, out of bounds, okay, or potentially out of bounds, if I'm on the board, I want it to be recorded in the minutes that I voted no.
Right.
To whatever that action was, just in case it does turn into a problem later, a lawsuit or something. I don't want to be named in that suit as one of the directors who approved this action that's now being challenged. And if you really want to be, again, the law says you have to show yes, no, or abstention for every director. So if you really want to dot I's and cross T's, that's the way to do it. List every director for every vote and how they voted.
Okay.
I mean, that's what the statute does say. So, that is the best way that's really the way it should be done.
Another reason not to have a 15-person board. I guess sometimes you have to, but I understand that there's sometimes that you've got large associations and every place has to be represented, but it's just kind of that gets kind of difficult. It's funny because I know in the nonprofit world, not the association world, but in the nonprofit world, a lot of nonprofits have, they want large boards for community involvement, so they'll have 15 or 18-person boards, but they're unworkable for operating purposes. So a lot of times they'll create an operating entity they'll consist of, 5 members, and usually from the full board, whose job it is to handle the day-to-day operating decisions. But anyway, yeah, I was glad that Connie called, because I wanted to discuss this, and get some information on it, because it's an interesting question, and some things that come up from time to time. So the other thing that I know we were talking about is well, we're going to have I think we're going to call her here in a second. Let me get this from Mike, and we'll get our caller on. Jim, go ahead, Jim.
Hi there.
Hi.
Calling again, and listening interestingly to the discussion. I certainly would move out of that association that was just described. But I'd move in a hurry.
Want to be president? Making money.
That's right. Yeah, they're getting paid good. You could be president.
Yeah, I've never heard of such an arrangement that the other unit owners would ever approve unless they were entirely willing to turn over everything to one person's thinking. But anyway, I'm calling because last week I called and we spoke in depth about the law on records and my plan to eliminate any treasurer's records after they're more than 7 years old. Today I want to ask about personnel records. In looking at that same section, there is in there, not in the first 6, but in there a all-inclusive clause that says or sentence that says you keep every other record associated with association business. I can't find anywhere else other than that sentence that would include personnel records. We do have some, and we have a full-time employee maintenance person. So there is a record, and he's been here a long time. So I'm assuming, and this is a question, that broad sentence includes personnel records and that they also can be disposed of after 7 years. Do you agree, Peter?
Yeah, I mean, personnel records are, again, they're part of the official records. And unless they're in the list of what has to be kept, in essence, forever, yeah, they can be. They also are subject to the 7 year limitation. The 7 year restriction.
I would say though, as long as that person is still employed.
Yeah, when they're employed, you probably want to hold on to the record anyway.
Oh, yes.
7 years after the time they're not employed, I would say you're probably good. Frankly,
right.
It's probably
I would agree.
Less, but 7, yeah. But
I'm looking back into the older records files, and I'm finding employees that have been here and gone more than 7 years ago. And I wondered if there are any federal requirements or state requirements that might come into play on that 7 year rule.
Not that I'm aware of.
Well, that's good enough for me because I couldn't think of any either.
The only, like I say, the only thing there would be, I don't know what the time period is for a person to bring an action on discrimination or any kind of labor law violation, and it would probably be, and there's probably a period of time before that in which you have to maintain records, or you're potentially subject to, you'd be subject to their interpretation of what I'm thinking about, time clock records and things like that, and time sheets or pay records that would show how many hours the person worked. I will tell you this, it's interesting, Jim, that you bring this up because this is an area that right now associations are basically a potential target. There are attorneys right now. There was a change in the labor laws a few years ago, relative to independent contractors and some other things. And so what's happening is that, most of the time you can't get an attorney, and Peter will tell you can't get an attorney to take a personal injury case or a discrimination case unless they're going to get, unless they're pretty sure of it, because it's usually on a contingency basis, and they want the money, and they're not going to get paid if they don't win the case. So they usually don't take it unless there's insurance involved or something like that. But these labor cases now, they are a different story. And what they do is they're coming in and looking for back pay, back wages, overtime, and things like that. Well,
right.
But under that law, the attorneys are allowed to be paid separately without reference to the amount that the person gets. So you could actually have a person that's awarded $2,000 in damages or $3,000 in damages, and the attorney could be entitled to a $7,000 legal bill.
Wow.
Yeah, and there are a couple people. There's a guy in Stewart that he does this for a living. He finds these cases and goes out and pursues them, and he's good at it. and he sends a few memos and makes $4,000 or $5,000. It costs the association $25,000-$30,000, and it and then he goes away, goes on to the next place. But so when it's related to records that show that the person was either an independent contractor or an employee, that specifically reflects that, and there should be records if you got an independent contractor of their insurance, of their that they are an independent contractor, their licenses and all those kind of things. And then the other thing, and the hours that generally the hours they work. The interesting thing is you cannot ask an exempt employee to track hours. You're really not supposed to ask them to track hours because that's not a factor. But at the same time, if it turns out that they're not exempt, you're kind of sitting out hanging in the wind because you don't have any documentation of the hours they actually worked. So that's why I say this area that's happening right now is very dangerous to associations or any business, because there's no way to document. You have a person that you're convinced is an exempt employee. You've done everything appropriate for an exempt employee, and now all of a sudden that person comes back with an attorney and claims that they were not. And so it's a tough situation.
Yes, it's interesting that you should tell me that. And fortunately, when I came on the board initially a dozen years ago, my background was in public administration, so I wrote the personnel rules, and I was aware of the difference between exempt and non-exempt.
Right.
With regard to our maintenance person, who is certainly not exempt, we keep the records there, the payroll records that we send to the accountant by week and by hours, and we went through all the necessary training, and the employee has signed off on all that stuff for safety. So I've tried. That was a while back.
And here's the thing, Jim, and this you might want to take a look at it since you're familiar with that kind of stuff. Back in I think it was 2016, or it might have been even 2014, 15, somewhere in that range, under the Obama administration, the Department of Labor modified the definition of exempt employee.
Yes,
and it used to be that they, it used to be if the person had a college degree and some things like that, there were some that doesn't apply anymore. In fact, it used to be that, like, say, for example, you had a position that required, let's say, a college degree. Under the new rules, if you had anybody in that position who didn't have a college degree or that kind of license, maybe they just had 40 years of experience or something, that tainted that whole job classification. Even though you had one, they made it, if you were a supervisor, you had to supervise 20 people, and none of your time could be spent actually doing work, other than supervision. That's
quite a change.
Yes, that was a big change. And so that's where this has opened up this door, because all of these people that would have been considered exempt under the old rules were now not meeting the qualification of exempt. And and there's treble damages on these labor, there's treble damages on some of these labor violations.
If I had to,
and actually, you know what? There are some federal and state laws for how long you have to keep employment records. Quite frankly, I've never been asked this. I think under federal it might be 3 years, and state 1 year from when they terminate their employment. So, that's something I does need a little bit of research. There are some laws. I think you're fine if you keep them 7 years from when the employee is no longer there. But actually, Jim, there are some specific provisions that I, quite frankly, have not been asked to review previously, believe it or not.
But they're not longer than 7 years.
I don't believe so. No. From when the employee no longer works there. I think it's a year. I think it's a year and 3 years. I think it's a year state and 3 federal. I think, but I'd have to check out. I have to check it out.
The other employee we have is a CAM, a manager, and he is an independent contractor by contract with all the insurance and all that stuff. And yes, we maintain his file in that manner. So
and that Jim, again, is something to look at, because here's the thing, and that's, and I have a CAM license as well, and I'm a CPA, and of course for all my clients I'm an independent contractor, but that area of independent contractor, that whole area is now real murky, because it used to be that there was a 20-step test, and it wasn't like if you met 11 you were good, and they were weighted based on the circumstances. So it has always been a murky area as to whether or not a person met the standard of an independent contractor. Here's the problem with independent contractors: they're all independent contractors when you're talking about the IRS. Okay, they'll help you when it's the IRS, but what you're going to find out is they're going to be claiming they're an employee when they got hurt and they're looking at workers' comp and they can't work anymore. That's when independent contractors file claims as employees, and they're going to be on the side. They're going to be against you at that point. So I've heard independent contractors say, "Oh, no, I'm good with this. Yeah, I'll sign it. I'm good with this. I'm good with this." And then as soon as they get hurt and can't work anymore, they immediately say, "Wait a minute, I want workers' comp." And they say, "Well, you weren't an employee. We don't. You're not covered." Well, yeah, I was an employee, and then they start making the case, and then you get into whether they're an employee, workers' comp, overtime, and all those kind of things.
Yeah.
What it comes down to is if you have a person that's acting as, let's say, a situation we just were talking about on the previous call, you've got an individual who has a CAM license, so they're going to work for the association. So they immediately set up an LLC. They're the only member of the LLC, and they set it up to be an independent contractor. They have no employees, and they don't work for anybody else. They don't do any other associations other than yours. That's going to be hard to get that to be an independent contractor. That's going to be some people arguing about that being, and the trouble is you've got the federal government going after it because independent contractors aren't governed by the Health Care Act. And so, the whole purpose of getting rid of these independent contractors was to force the person to be an employee so they'd be covered under the Affordable Care Act. And the mechanism is in place right now to eliminate all these independent contractors. There used to be a provision that if it was common practice in your industry for the person to be treated as an independent contractor, then they could be an independent contractor. Technically, if you were under audit, you could go to your competitor, and if they were doing the same thing and they would testify to that effect, nobody would, that you could say, okay, I'm an independent contractor, and they would have to abide by that. It would be an industry standard. That's gone by the wayside now.
Wow.
Some of the state statutes relative, for example, one that a lot of people are familiar with is the nurse registry home health care issue. There was always an exemption in the statutes in state law for the last probably 20 years that those individuals meet the criteria to be independent contractors by statute. That statute has been eliminated now, and the government is aggressively pursuing nurse registries and home nurse registries to get those people treated as employees and not independent contractors. So
let me ask you, before we run out of time here, and I have to sign off, do you know of any case law recent on this subject as far as CAMs go?
As far as CAMs and independent contractors?
Yeah.
No, I don't know of any, but I haven't looked. I would imagine that if you start looking at some workers' comp cases, you'll see some. That's usually where it comes up.
Okay, good idea.
They get hurt on site, they can't work anymore, and that kind of thing. That's really what happens.
And I would expect the nexus there would be the kinds of things that you ask the CAM manager to do in the contract. We were very careful when we constructed the contract. He and I wrote it together, and it has lasted all these years, now 5, as to balance the relationship between the manager and the board, hoping that we'd never got a situation like you just heard from the previous caller.
Yeah.
And let's put it this way. I've worked for boards myself, and I've been on them, so I knew how to craft that, and he was helpful in doing that. So we have a good contract. I will go back, though, and look at it in light of what you've said.
And I tell you, Jim, what it's going to come down to, it comes down to really two basic things. One, does the person work for anybody else? If they don't work for anybody else, that's strike one. And then the other situation is, can they lose money? In other words, if they just show up and you're paying them on an hourly basis or paying them for a certain number of hours and all they have to do is show up, they don't have any risk of loss, no opportunity cost. And a risk of loss would be making less than, $25 an hour or whatever, that, less than minimum wage for sure, but making less than the standard wage. So if they're in a situation where they have no ability to lose money because they don't have any expenses and they just have to show up and work, and you're their only client, you probably got a problem. That one's going to, that can be pierced from the standpoint of them being an employee, not an independent contractor. Anyway, we're running out of time, but Jim, you're please, call back if you want to discuss it further. We'd be happy to have you call back next week and discuss it. You brought up some good points for our listeners, so appreciate your call.
Well, I'm back now, so I certainly listen to your show again. Enjoy it very much. I'll let you go, and see you soon.
All right. Thanks. And Peter, as always, thanks for all your knowledge and expertise and all of the things you bring to the show. And we'll be back next Monday right here on WSTU Digital 1450. We are Martin County's Heritage Station.